We're on the record. This is the meeting of the Sunshine Ordinance Task Force Education on February 20th, 2018. The time is 3:40. On the call of the roll, Member Eldon.
Present.
Eldon present. Member Fisher. Fisher has informed me that she will be delayed till approximately 4:30. Chair Wolf.
Present.
Wolf present. We have a quorum. There are no agenda changes that I know of at this time.
All right.
Next on the agenda, item number 2, adoption of the minutes for the October 17, 2017 EOTC meeting.
All right. Is there a motion to approve and adopt the minutes?
Motion. I will make a motion to approve.
All right. Seconded.
Comment.
Is there any public comment on the approval of the minutes? Seeing none, go ahead and call the roll.
On the adoption of the minutes, Member Eldon.
Yes, aye.
Eldon, aye. Fisher, absent. Chair Wolf.
Aye.
Wolf, aye. The minute passes. Item number 3, public comment. Members of the public may address the Education, Outreach, and Training Committee on matters that are within the committee's jurisdiction but not on today's agenda.
All right. Is there any members of the public that would like to address this committee in general public comment? Mr. Petros, are you approaching
No.
for general public comment? Or okay, seeing none. Wait, I'm sorry. There is someone that would like to participate in. Ma'am, you would like to make a general public comment?
I would, but I would like to look at the agenda first.
We can just put it off.
We'll go ahead and hold general public comment until after the next item to give you a chance to prepare any remarks you'd like to make. Is that all right?
Thank you.
You're welcome. All right, go ahead and read the next item, please.
Next on the agenda, item number 4, file number 18007, complaint filed by Michael Petrellis against former acting mayor London Breed and the office of the mayor for allegedly violating administrative code section 67.25 by failing to respond to an immediate disclosure request in a timely and or complete manner.
Great. Thank you for coming, Mr. Petrellis. Is there anyone from the respondents that's here at this point in time? And what agency are you with, sir?
The mayor's office.
The mayor's office. And is there anyone else responding? Great.
With the mayor's office?
All right. How many minutes, Victor, do we give for the...
5 minutes.
5 minutes. All right. If you can put 5 minutes for Mr. Petrellis.
Hello, Michael Petrellis. I made a request for Acting Mayor London Breed's calendar as mayor, the calendar that is detailed in terms of who she met with and what items were discussed at the meeting. This was for her acting mayoral calendar. So I received some responsive public records that gave me information about meetings that she had held, and other items on her agenda. And it was a bit more detailed than what's available as her press calendar, I think they call it, that's on the mayor's website. I then had to follow up with the mayor's office in terms of getting the list of names of who was at the meeting and what was discussed, because that information is required as part of the calendar law that applies to the mayor and the soups now. And eventually, Victor Lim did get me that other calendar. I'm going to say it's the Prop G calendar. A little bit confused right now about which is the Prop G calendar that they keep for the mayor. I feel that even though the mayor's office eventually got me the full calendar with list of attendees and items that were discussed, it shouldn't have taken follow-up email and extra time to get that information. That's the gist of my complaint.
Okay, thank you. And respondent, if we can.
Good afternoon. Victor Lim, Deputy Communications Director from the Mayor's Office. Chair Wolf and Mr. Eldon, good afternoon. So I'm here today to respond to complaint number 18007 filed by Mr. Petralis on February the 5th and was received by our office on February the 8th, 2018. Mr. Petralis alleges that former acting Mayor London Breed and the Office of the Mayor violated Section 67.25 of the Sunshine Ordinance, Administrative Code Section 67.25, for failing to respond to an IDR in a timely and or complete manner. Specifically, Mr. Petralis alleges that acting Mayor London Breed's calendar and the Mayor's office produced in response to his request does not disclose the Mayor with and what topics were discussed in violation of the Sections 67.29-5 of the Sunshine Ordinance. However, we respectfully request that the task force should dismiss this complaint. The Mayor's office produced a calendar that discloses meeting attendees and the general subject matter of the meetings in compliance with 67.29-5. A little bit of background on the 22nd of January of this year, the Mayor's office received Mr. Petralis' IDR request via email requesting the following documents: a copy of your detailed full schedule of your official events and meetings held in City Hall or elsewhere as part of your official duties for the period of December 12th, 2017 through January 27th, 2018. And for that period of time for the request, Supervisor Breed was serving as the president of the Board of Supervisors and also as acting mayor pursuant to Section 13.101.5 B of the San Francisco Charter due to the death of former Mayor Edwin Lee. On the 23rd of January, we produced records in response to Mr. Petralis' request. On the 25th, Mr. Petralis sent a follow-up email stating that I have received the responsive records. However, there are outstanding matters of my request for a list of attendees and topics discussed as the acting mayor's meetings. So on the 29th, our office informed Mr. Petralis that we would review the calendar and the issues he raised in his email and provide a supplemental response as soon as possible. On the 7th of this month, we completed our review and provided Mr. Petralis supplemental records to address the issues he raised on his 25th email on 25th of January. We attach our response here. Actually, Mr. Young, you have copies, or should I submit copies?
I did not print out the email received on Friday.
I have one copy if needed later. Okay. And so, in response to the complaint, Section 67.29-5 requires that the mayor and the members of the Board of Supervisors, among others, to maintain a daily calendar that records the time, place, and a general statement of issues discussed at official meetings. For meetings with fewer than 10 attendees, the calendar must also include the names of attendees and the organizations that they represent, subject to certain exceptions, including where disclosure of attendees should review confidential or would review confidential information protected by other laws, where city business is discussed only incidentally, and where all attendees are employees or officers of the officials department. Here, while the exact nature of Mr. Petralis' complaint is unclear, our supplemental response satisfies this requirement of Section 67.29-5. The calendar includes the official meetings Supervisor Breed took in her role as acting mayor and as a member of the Board of Supervisors. Each meeting includes a general statement of the issues discussed, and the attendees are disclosed in each instance where 67.29-5 requires disclosure. In fact, our response provides a general disclosure of attendees, for example, mayor's office staff, where Section 67.29-5 requires no disclosure at all. Mr. Petralis may contend that 67.29-5 requires disclosure of attendees for meetings of fewer than 10 people attended by staff from both the mayor's office and the Board of Supervisors. But in this extraordinary circumstance, while Supervisor Breed served as the dual roles of acting mayor and board president, Her department, for purposes of the calendar, was both the mayor's office and the board of supervisors. The exception to the requirement to list attendees where all attendees are employees or officers in the official's city's department thus applies to such meetings, and disclose of the attendees is not necessary. Admin Code Section 67.29-5E. For the reasons stated.
Is that everything?
Yes, sir.
Okay, great. Thank you. Go ahead and stay up there, actually. So it seemed you were reading from a statement, and I had a little bit of time following some pieces of that, so I'm just going to kind of walk through a couple things to understand here. So in the testimony from Mr. Petrellis, and we'll get to him in a second, it sounds like he eventually got what he was after.
Correct.
However, it wasn't until the February 7th that he received those documents. So there was about 2 weeks from the time the initial request, give or take. That no one seems to contest that. So about 2 weeks. Why did it take that long to investigate and prepare this document?
So at first we did give an initial response to Mr. Petrellis, and
right on the 23rd. On the 23rd, you provided some calendar that didn't meet the criterion that he asked for, and then it took another 2 weeks approximately to give this revised response.
Yes, and we apologize for this delay, and we are here to explain. So at the time of Mayor Lee's death, there was a delay in acting Mayor Breed in physically actually working in the mayor's office in room 200. Now, Mayor Breed at the time, out of respect for Mayor Lee, his family, and also the staff, she did not choose to conduct meetings in room 200. So as a result, there was a lapse in some of the record keeping that was required. So when we caught this issue, we immediately followed up. We retroactively worked with the members of the mayor's office and the District 5 legislative staff to thoroughly check on the days of the meetings that Mr. Petrellis had concerns about that may not have met the requirements and perhaps not properly recorded. So then we provided an update with the supplemental document to ensure that we met his needs. And as a result, in this transition, now with Mayor Farrell in our office, we're making sure that our records are diligently kept.
So whose office was maintaining these records that were incomplete? Was that someone from your department, the mayor's office, or was that someone from Supervisor London Breed's office that didn't have these? Because essentially what I'm hearing is that the records that were maintained for the calendar did not contain a complete data set, which you then went backwards to supplement. Is that an accurate statement?
That's correct, sir.
Okay, so whose office was created the incomplete documents in the first place?
The mayor's scheduling colleagues were keeping the documents, so the scheduling division.
So the scheduling division, so the people that continue to work in the mayor's office, not
Correct.
the people that are associated with London Breed.
Correct.
And this is because they were used to scheduling meetings in room 200, and these meetings were scheduled off-site, so there was a disconnect in communication?
Correct.
Great. So this is no longer a problem moving forward. So if Mr. Petrellis were to make a request for the following calendar, starting with when Acting Mayor Farrell took office, he would receive responsive records that had all of the information as an IDR, and there wouldn't be any issues.
Correct, sir.
And presumably with the next administration, there'd be no hiccup at all. This is an incidental problem that happened due to the circumstances, not a systemic issue.
Correct.
Great. Do you have any questions for the Office of the Mayor?
I don't. You covered them very nicely.
Great, thanks. All right, Mr. Petrellis, can you, thank you so much.
Thank you, sir.
So it seems to me that from the testimony I'm hearing that essentially there was, during that interim period, formerly Acting Mayor London Breed, which it's a strange tongue twister, was also acting as supervisor during those times. So she had potentially 2 calendars that you're shaking your head no. Go ahead and...
I'm just saying I don't know.
So did you both request the calendar for acting Mayor London Breed as well as supervisor London Breed during that time period, or just acting Mayor London Breed?
Just acting Mayor London Breed.
Great, thanks. That's the only question I have for you. Anything on your end?
No.
All right, thank you. Let's see, do we need rebuttals? Or should we discuss before rebuttals?
I mean, it basically looks like there was a sort of...
Microphone, please.
It basically looks like there was a sort of delay that we typically find violations for, and that it happened for an understandable reason and has been resolved. So it feels ultimately like a responsiveness delay.
And would you see that as a 6721 or a 6725?
Probably 21.
All right. Let's go ahead and hear some rebuttals. Do you guys, either of you have any closing remarks before we move on to a motion?
Yes. Hello, Michael Petralis again. I didn't like hearing from Victor about the incomplete records are being kept by the mayoral staff. I believe that even with the unexpected death of the mayor, that keeping calendars are essential parts of the job. The second thing I wish to mention is that I believe a year or so ago, maybe it was 2 years ago, when I had similar troubles with the mayor's staff about Steve Cowa's calendar. He was the chief of staff to the mayor. I thought a lot of clarity came out of that complaint in terms of how the mayor and his staff will keep their calendars, and I'm hoping for guidance from the full task force to be provided to the mayor's office about proper calendar record keeping and disclosure.
Thank you.
So again, we apologize for this lapse in disclosing the necessary information to Mr. Petralis. Several things. In regards to the calendar, it was treated as one office. So we worked closely with the D5, District 5 office to make sure that when we ultimately disclose the final packet, it was a complete disclosure of both the mayor and board president Breed's schedule. In response to what Mr. Petralis mentioned with Mr. Steve Cava, he has actually retired. It's also prior to my time as custodian of records. I joined November of 2016. And also some of the staff that were there are no longer in that office. We have new a director of scheduling that's taking care of the schedule, and also as this issue has raised, we have spoken with legal counsel and with the mayor's office to ensure that this does not happen again in the future.
Great, thank
you, sir.
Just if you could stay there for one second, because I realized that opened up a question, because essentially you're saying that if Mr. Petralis had requested a calendar from Supervisor Breed, at this point there's one complete document that contains the entirety of both her calendar as mayor and supervisor. Is that what you...
Which is the document that we have submitted to the task force.
Great. So is there a clear delineation between which meetings she's as mayor and which meetings she's as supervisor in the documents you provided to Mr. Petralis?
There's a reflection of which staffers were staffing the mayor at the time. So if the meeting involved 10 or less with only the mayor's office staff, it would say mayoral staff. And if it was District 5 staff, it would say District 5 staff. This is unprecedented, so we tried our best to disclose this information as best as possible.
I mean, I hear that, and for the most part, this sounds fine, but there is essentially a legal duty for both a supervisorial calendar for President Breed during that time, and there's also a legal requirement for a calendar for acting Mayor Breed at the time. So does a discrete calendar of both exist?
To my knowledge, Mayor Breed's staff at the time, the District 5 staff, also handled her schedule accordingly. But I can't speak on their behalf right now.
Okay. I think this starts to get the edge of where our responsibility lies, but in terms of like the overall record keeping of these calendars, whether or not there is a discrete calendar for Supervisor Breed during that period and a discrete calendar for acting Mayor Breed does open up some interesting questions, which we may revisit when we refer this to the full task force. So thank you very much.
Thank you.
Do you have a motion to make?
Yeah, I actually. 6725 may be better. I mean, there's the timeliness and there's the incomplete information. Those seem to both be factors here.
So, I mean, we're really just making a recommendation, so we can base it around exploring 6721 and 6725. Which one of those is one of those related to the records keeping?
So 25 is immediacy of response, and they took a couple weeks to get it back.
And 21 is
the process of filing.
So there's also potentially, a maintaining records of violation, which I don't know which section that is. Do we want to have the full task force explore all three of those, or what are you thinking?
Reading. So 6721D would address the incomplete nature of the records they provided back within the time frame, or even outside of the time frame, and then 6720. I mean,
Can you pull the mic closer?
yeah. I'm just trying to think through this.
I mean, 6729.5 seems like something we could potentially be looking at in addition to the other two, is where I was going. I don't know whether it's really warranted. It seems like this was sort of a circumstantial matter that they've since gone back and corrected. But those are the...
There's also 6729.1, which is records survive transition of officials. I don't think any records were destroyed, but that is where the inconsistencies were. I mean, ultimately, if they seem to have addressed the key problem, which is, there's not really, besides, whatever violation occurred in the past, we're not really looking at anything happening here in the future that we know of.
Yeah, I mean... So you prepared to make a motion then?
I will...
I mean, we can reduce it just down to finding a violation and not naming it.
Yeah, 67. We could find a violation. 6721D covers both the time frame and the completeness, I believe. So to me, that one would sort of address what happened, but I mean, I think there are other ways. There are other things you could add on here. I'm ready to make a motion for 6721D as a violation.
Okay,
We can-
I'll go ahead and second that. We have plenty of opportunity to sort of reopen the box in the full task
my
force.
motion
So
is to find a violation for 6721D. Is not timely and it was incomplete.
The motion is to find a violation of 67.21D. Actually, it's not to find a violation, but it's to make a recommendation to the full task force that a violation of 67.21D regarding timeliness and completeness occurred. And I believe the motion is to refer is to find that the task force has jurisdiction and to refer it to the full task force with that recommendation.
sounds good.
Public comment?
Is there any public comment on this motion?
I can restate.
So, no public comment?
Commenting on this particular.
Okay, great. Thank you. All right, seeing no public comment, go ahead and call the roll.
On that motion, Member Eldon.
Aye.
Eldon, aye. Fisher, absent. Chair Wolf.
Aye.
Wolf, aye. The motion passes. I will notify the parties when this matter is rescheduled before the full task force. Thank you. Would you like to take general public?
Yeah, let's go back to general public comment now. This is the time to speak to any issues concerning the committee that are not on the existing agenda.
I'm here. My name is
Ma'am, if you can actually speak into the mic so that it's recorded for our records, we'd be an awkward committee to not get the full recording.
All right. Thank you. My name is Nancy Cross, Cross, and I have something that I would like to be on the agenda to do something about. I see that you are interested in, where did I put my paper? Oh, here it is. I see that you are interested in Education Outreach and Training Committee. And this is something about the access by the public to your committee agendas and meetings, and whether they are successful in what you have done so far as to make them accessible through the library. As you probably know, on the 5th floor they have a book that files your agendas a certain amount of days before. And I would say that they have not succeeded in complying with the law for reasons that I will give you an indication of their nature. I have another complaint that is different from that, which I also would like you to agendize. But the one, first on the library, is that you send your agendas to the library maybe on Friday, and they get them on Saturday, but they stamp them as received on Friday, but when they're mailed, they get to the library on Saturday. They're not posted on Saturday. They're not processed until Monday, which shortens the time of access by the public to know in advance of your meetings and maybe come to them. When they don't know, when they have only to look on the very day of your meeting or the day before, that's cutting down what is required by the Sunshine Ordinance and also the state law. So I'd like you to look at, and I talked to the library about this, and they tell me about the processing, when the processing is. But if the processing isn't until Monday, but you think you have it stamped when it's received on Saturday, you see that the stamp doesn't correspond to when it's available to the public. And I think what is considered available to the public doesn't happen until 2 days after you think you've done it, just because of that diversity from the stamp.
Great, thank you.
Are there any questions? Do you understand what I'm saying?
I understand what you're saying. I want to let you know that we have a process to actually file those complaints so that we can look into them, and hopefully you can speak to Victor, our clerk, who can point you to the resources to file such complaint. And then we can actually, call the library in to actually find out what's going on. Beyond that, in terms of the Sunshine Task Force, there's a number of complainants that have raised past complaints with the library who may be valuable resources to you in formulating a complaint and moving forward through the process, because I understand it can be a little intimidating.
I think that since this is not a personal complaint, that it might be of interest to your commission and the committee, the task force, to get it corrected, not for me to find out or me to push it, but me to inform you of something that you haven't checked up on what happens to whether you comply, your committee and task force comply with the law, not whether I'm making a complaint, but simply I'm giving you information that there's something to be researched before you can validly consider yourself complying with the law.
I understand exactly what you're saying, and I will reach out to the chair of the task force as a whole, because we're just a committee. But the way that the task force is designed to work is that we're sort of a quasi-judicial body that hears complaints and then decides how to adjudicate the complaints. We're not really built to do investigations and then act upon them, because that creates a weird space for us in the process. So I'll reach out to our chair and figure out what we can do. And in the meanwhile, if you feel inclined to file a complaint, that would be the easiest way for us to start addressing it.
Well, it may be the easiest way, but I think that's one reason we have the homelessness and a lot of problems in San Francisco that we don't need to have, is that there is a running away from complying with the law because you don't check up whether you are complying. You just say, we haven't any force for checking up.
I do understand, ma'am, and thank you for your time. It's less about not wanting to do the work and trying to figure out how to do it within the regulations that define us.
Yeah.
But I will reach out to the board chair and see what we can do.
I thank you for that. May I mention another concern?
I'm afraid we have a limited time for public comment, but thank you so much for taking the time to speak to us today. Is there anyone else here for public comment? All right, seeing none, go ahead.
I think you will not have another person, me come again in order to talk 3 minutes on something else. And if that's not important to you, I accept your decision and will leave the...
It's not a... How do you feel about giving her another 2 minutes to...
But I can't be running back and forth to...
I understand, ma'am. Give me a minute to consult with my...
That you haven't a process for finding out.
Give me a second to consult with my colleagues.
It's a standard 3 minutes per person. I think if you change it for one person, then it gets complicated for everyone. So we can't do that.
I'm afraid our hands are tied. If you'd like to submit a letter to Victor or to ask us to agendize an item, we can take the time to actually hear it.
I would like you to agendize an item on your agenda to look into the San Francisco Human Services Commission. I went to the agenda, the thing is that they are not distributing at their meeting the copy of the materials used for action at the committee meeting. And where do you get the materials? Well, after the fact, after they made the decision of the day. And also, I would say...
So again, that sounds like another good complaint to file. And again, our hands are sort of tied to adjudicate complaints and not to investigate them. But
Like
Victor...
the process, if you put this in writing and Victor can help you do that, then
I can't afford my time that way. I can afford to bring you facts you don't otherwise get. But there are too many things in San Francisco that need to have writing and use the internet and do it with a lot of formality when they're a matter of public.
We have a long list to get through, and we have
I'll
to be
come to
efficient
your
with our
meeting,
time
and
as well.
if you want me to talk 5 minutes or 2 minutes or something, I have to do what you say. But you'd lose the input that I don't see any reason why you shouldn't exercise it. You don't have a lot of
Ma'am,
people.
public comment is over. We need to move on our agenda. Thank you very much.
Victor, before we move on, if there is a reason that someone can't submit a request or a complaint in writing, is there a process to submit it by voice?
I can complete a complaint, but when it comes down to it, someone actually has to show up at the meeting and provide argument at that meeting, as we're doing here.
But if she's willing to call and explain her complaint to you, you could file it and we could investigate
But
it.
when it comes to the hearing itself, somebody will need to show up.
Ma'am, if you call Victor or at
I
the...
can make a local telephone call if I know the person and what their role is and what kind of information they want. Maybe put this on the agenda if that's...
Yeah, so if you call the task force, Victor, what's the easiest way to get that number to her?
I can write it down quickly.
Okay, Victor will go ahead and write down the phone number, and if you go and you call him, it'll be the same person, Victor, that you'll call, and then you can go ahead and say what these complaints are, and that'll open the file for us to start the investigation. There will be a follow-up hearing, and in order to move forward, you'd need to come back for the hearing. I didn't think you would. Great. Thank you.
I see the number here.
Wonderful.
Are there certain hours?
Standard work hours, 8 to 5.
9 to 5 or something?
Yes.
All right. Thank you very much.
Great, thank you. Moving on.
Next on the agenda, item number 5, file number 17087, complaint filed by Ray Hartz against the Office of the Mayor for allegedly violating Administrative Code, Section 67.31, by failing to administer and coordinate the implementation of the provisions of the Sunshine Ordinance for departments under the control of boards and commissions appointed by the mayor.
Is Mr. Hartz here? Doesn't seem to be. Did you hear from Mr. Hertz about his attendance in one way or the other?
He did not inform me if he was going to attend or not. However, I do know he received the email notice of hearing, as he did respond in the renaming of the title to remove the name of former Mayor Edwin Lee. So he was aware of the meeting. Our standard practice in our complaint procedures would be to table it if the complainant that fails to appear and does not provide advance notice.
Is there a motion to table it?
I mean, is there any option?
I mean, I think we could still. I mean, the representative from the office of the mayor is here. The Mr. Hart's complaint is written out, so it's possible to look at it, but at the end, it's still going to get tabled. It seems what's more respectful to the mayor's office to take an additional 5 minutes to hear the first part of this and then drag them back out, or to excuse them now.
I'm fine going through with it now. Talking to them.
And just so the audience is aware, if we do table it, notice will be sent to Mr. Hartz, and he will be allowed a certain amount of time to indicate that it was an accidental non-appearance, and then it would be automatically reopened. Or not automatically, but it could be reopened if he does indicate that it was an accident that he failed to appear today.
Great. And then if it would be reopened through our committee again, and we would not require the mayor's office to reappear because we already heard from them, correct?
If I would say that they would need to appear, as there will be a back and forth question and answer period. So,
Well, then
it's basically, if we table the matter today, it's closed, and it'll be reopened as needed, but both parties would need to appear at any hearing.
well, so I think we just have to table it. I'll make a motion to table it.
All right. I will second it. Is there any, do any of the parties want to speak to the motion to table this item? That's you.
You mean before we table it? Or?
Well, there's a motion to table it. Normally we call for public comment, but realistically, the only party that's probably engaged in about tabling it is you. So do you?
We have no objection to tabling it.
Okay, so then it may be reopened and we drag you back out, but it sounds like no matter what, we're going to drag you back out. So
I could speak right now if need be, for the record.
It probably is not a good idea, as when we've done that in the past, it just opens up additional questions, and the parties would still need to come back anyway.
Sure. On Victor's advisement, seeing no public comment on. Okay, go ahead. Any public comment on the motion to table?
I think that's a wise move to not hear from the party that's here, because in the past there have been issues with that, particularly concerning Ray Hart's.
Thank you. Any other public comment? Seeing none, call the roll.
On the motion to table the matter, Member Eldon.
Aye.
Eldon, aye. Member Fisher, absent. Member Wolf.
Aye.
Chair Wolf, aye. The motion passes. Next on the agenda is item number 6.
And Victor, on the notes for item 5, can you make a note that the office of the mayor was present?
Yes.
Great. Thank you. Thank you for your time, sir.
Next on the agenda is item number 6, file number 17086, complaint filed by Ray Hartz against Dennis Herrera and Bradley Rusi, Office of the City Attorney, for allegedly violating the Administrative Code, Section 67.21I, by acting as legal counsel for city employees or any person having custody of public records for the purpose of denying access to the public.
All right. And I'm assuming Ray Hartz didn't sneak in through teleportation. And you, sir, are with the city attorney's office?
That's correct. Do you need me to go up to the microphone?
We probably will for the next item, but I don't think we do right now.
Sure. John Cote with the city attorney's office.
Great. Is there a motion to table this item as well?
I make the motion to table this item.
Second. Is there any public comment? Seeing none, go ahead and call the roll.
On the motion to table, Member Eldon.
Aye.
Eldon, aye. Member Fisher, absent. Chair Wolf.
Aye.
Wolf, aye. The motion passes.
And like before, can you make a note that the representative from the city attorney's office was present?
Yes.
Great. Thank you. Go ahead and call the next item.
Next on the agenda, item number 7, 17109, complaint filed by Anthropo against Diane Rosenstein, Office of the City Attorney, for allegedly violating Administrative Code, Section 67.25, by failing to respond to immediate disclosure requests in a timely and/or complete manner.
And before we begin, Ms. Trudeau, are you here for this item as well, sir? As in representative? Great. Thank you. All right. Go ahead.
Okay, so I provided a timeline on page 139 and 140. What I forgot to include was a subsequent email that I sent to Shane Gilbertson on October 13th, which I didn't get a response to. Here. I forget how to turn it on, but there is an email there. So this was a late response. I went out of my way to call the reception area on the 28th, asking for this Shane Gilbertson, and I was told there was no number for him. So I filed this response. What I'm asking you guys to do is to fine for 6730C, a willful violation, because in total there have been 27 orders of determination that issued against the City Attorney's Office from 2008 to 2018. 24 of the 27 began with late responses, no response, or a 14-day extension with no response, which is what this is. There were 4 referrals to ethics, and Shane Gilbertson was responsible for 3 of the orders that I've gotten against the City Attorney's Office and one that I filed this morning for the exact same issue. And on his response email, there wasn't even a phone number, so there was that. There are the violations 6721A, C, and D, which is the late response, no response, 6729.7 and .5 for withholding of documents, and 6726. Basically, nobody asked me any questions. Who is Mark Tetro? What is his relationship? They just spewed out their generic attorney-client privilege. Well, Mark Tetro is not a city employee. He's not even affiliated with any department in San Francisco. So there's that. They didn't list what they had, what they didn't have. There was nothing. It was just, we'll get back to you, and then that was it. With regard to the faulty email, once again, this is the same excuse on the last order I got on Margaret Baumgardner. It was sent to the wrong address. Well, how can that be? Because I got a response from them on the correct address. We'll get back to you. So they had it. And their claim through their exhibits is that they sent it to an address that came back to them. Well, they sent it to the wrong address. My email is aturbo10 at AOL. They sent it to aturbo10 at AOL. Well, that's not my email. And then if they're going to claim they sent it to, here it is. I don't know how to get this thing to work, so it goes up on the screen. Page 158 is the email they claim to have sent it to, which is not my email. I didn't receive it. Here. aturbo_10 at AOL. That's not my email. And then turbo2, that's long defunct because it was jammed up by ridiculous emails from Kate Patterson, filled to capacity. I haven't used that for a year or two. So the last time John Cote was here, he gave some story about how they're switching from Lotus to a different platform and yada yada, where it is the exact same mistake. It was a human error, and I would like to get the documents. I needed them for a certain reason, and I haven't gotten them.
Great. Thank you.
Okay.
All right, whenever you're ready, sir.
Great.
Oh, and if we can take that item off the overhead. Thanks.
So, good afternoon, task force members. John Cote. I'm the communications director for the city attorney's office. Thanks for having me this afternoon. Real quickly, as I'm sure you have, our response dated October 17th of 2017. It starts on page 151 of your packet. This was simply a situation where our department tried their hardest to be responsive to Ms. Trabeau, and for some reason, there was an email error. Now, Ms. Trabeau's representation is that her email address, atrabeau10, was incorrectly entered as atrabeau_10. That's certainly a possibility, but I'd like to note that the response here was due on October 10th. Our office responded in a timely fashion, got a bounce back notification, which you'll see is the response is on page 157. The bounce back notification that we got is on page 158. So our staff immediately, in an effort to be responsive to Ms. Trabeau, proactively searched to find another email address that she had communicated to our office with, and had communicated to our office with specifically about immediate disclosure request, sunshine requests. And that is on page 160 of your packet. And as you'll see in that email, which is dated in 2016, the subject there is a public records request. So our staff, in trying to take every step they could to provide this information to Ms. Trabeau, sent the response to that second email address. This is the Trabeau2 email address. And you can see that email on page 162 of your packet was sent same day, roughly 10 minutes after receiving the bounce back. And that second email did not bounce back. Now, Ms. Trabeau's representation is that she didn't get that, but we received no bounce back notification from there. In fact, at that point, thought that her request had been satisfied. The only indication that we got from her that she had not received our response was the complaint from this body. And at that point, you will see on page 163 of your packet that upon receiving that notification that she had not received these previous two emails, we emailed her again and sent both the initial response and the response that we sent to an alternate address, and apologized for her not receiving it earlier. Now, as to her representations about calling our office and things like that, there was no record or evidence or anything presented here that was the case. This is something that's wholly unsubstantiated, and the first I'm hearing of it. And I'm just reviewing a couple of things. That's essentially the gist of what we have here, and I'm happy to answer any questions you may have.
Why did you use a different email address than the one she had sent in? Was it just...
You're talking about when we got a bounce back and then decided we should try and find an...
Maybe I missed it. So the bounce back was to the correct email address?
That was our understanding, yes.
But it wasn't... Just to make sure I'm getting this correctly, the email you submitted this with was... atrabeau10, no space, right?
Yeah. I submitted
It's one at a time.
I'm just trying to make sure I have...
Yes, but into a
everyone agrees
microphone
on the
at
facts.
So I submitted an IDR in the subject line from atrabeau10. They responded to atrabeau10. Here you see on page 156 of your packet to the correct email address.
And then later, 10 days later, they responded to a different email address.
Yeah.
Mr. Cote, do you know why that why they selected a different email address instead of responding directly to the existing one?
My understanding is that our staff simply were replying to the same address.
Okay. It could have. What email system do you use again?
At this time, we had Lotus Notes. We've
Okay.
since transitioned, and we have
And is that would it have been a problem where maybe your office had corresponded with her on the previous address, and so that one had brought? I'm just trying to understand why that
Sure.
was a problem. I mean, what the interface to you, did it even distinguish between the two email addresses? Did you have to create a new thread? I'm just trying to track down the specifics of this so I can understand.
No, I understand that, and I have to apologize. I don't have that
I have
level
never
of detail.
used- I'm too young to use Lotus Notes. And I've worked
Sure.
in an industry
No,
where
I mean,
it's not
I'm
used
just.
anymore. So
I mean, I was not the individual staffer who was
Okay.
replying to this, and so I don't have that specific level of detail. My understanding is were you replying just to this thread? Did it auto-populate just to your email? My understanding is he was replying to her previous email and attached our response, and then it bounced back. And he was like, that's weird. What can I do to make sure that I get this to her? And he dug up another email address and sent it to that one, which is the Trebo 2
and that
address.
that happened after the 10th, though.
No, it was all on the 10th. It was all within 10 minutes on November 10th. The first one was sent at 4:51 p.m. on October 10th. The bounce back.
What page is this on again?
Sure, no problem.
Page
It's-
158.
Yeah, it actually, if I may, it starts on 157 is the original
Yeah.
response. You see, it's from Shane Gilbertson.
Okay, and then the response then included. So first you tried Trebo 2, which is the wrong.
No. First, we just replied to her email that she had sent the request on.
Right.
And that's what you're looking at page 157.
Right.
That's Shane Gilbertson from our office responding to her. Here's the response to your immediate disclosure request. And that was at 4:51 p.m. on November 10th. Now, if you look on the next page in your packet, page 151, that's the bounce back notification that Mr. Gilbertson received for that email that he sent at 4:51 p.m. I'm sorry, 158 if I misspoke. Page 158.
So I'm just trying to track the exchange from there. So 162.
So once he gets that delivery failure report,
Yeah.
he searches through our inbox for another email address for her. So what you see on page 160 is the email that he found that she had sent us on January 5th of 2016 about an immediate disclosure request. So he takes that email address, copies it, and sends our response again. Again, this is all happening on the same day, November 10th, 10 p.m. November 10th, and he sends this second email at 5:01 p.m. So he sent the original response at 4:51.
But
It
that
bounces
second
back.
one went to Trebo 2,
Correct.
not the original email.
Right. Because he
Trebo
thought he had
10
already responded to the
space.
original email,
Yeah.
and it wasn't working. He got a
Yeah.
bounce back. So he's like, I got to find an alternate email for her because
And-
the one I thought was her
Yeah.
correct email address just bounced back to me.
It turned out it was not the right alternate email.
That's the way it looks now.
Well, yeah,
But,
I understand.
but at the time, he was trying to be responsive.
Yeah,
Yeah.
Except what happened was that he sent the email to an email that added a 10 for some reason.
no, I added a space.
Added a space is what it
space
looks
before
like.
No, it's not. It's an underscore. It can't be a space.
I mean, underscore, yeah,
and adds the underscore
for the 10.
before the 10. Sure, and then that bounces, and then somehow instead of verifying that that was the correct email it was supposed to go to, he goes back to find an archived email before that step of like, did I send this to the right place that the last email I sent it to was? Because the first email, the email, confirming receipt, did go to the correct email. So there was some disconnect that we ended up going all the way back to this Trebo 2 email instead of to the first email.
If I may,
Go ahead.
I suspect that he assumed that the email program would have captured in the same way that you would reply to Gmail, and you would assume that Gmail correctly captures the reply address when you hit reply. That's what I assume he did, and that's not actually. Or did he just write in the? I mean, I don't understand what the Lotus Notes interface looks like here. If it's auto-populating with the reply to address from the existing thread, or if it requires you to enter a new email address.
No, it can certainly auto-populate and reply to.
Yeah, because if it had done that, it wouldn't have. I don't think it's a bug in Lotus that an extra space would have been introduced. So, I mean, I assume that's some form of administrative error. It seems a little too specific to be a bug.
I wasn't necessarily. I didn't suggest it was a bug in Lotus Notes. That wasn't.
Well, I'm trying to go through the possibilities.
Oh yeah, sure.
So I mean, I don't think it was an intentional error, but it does seem like you guys got the original email address wrong, and then you tried to follow up in good faith, and it was also not right. And I mean,
So when did the email get to the correct email address?
No, that's not true. Actually,
We'll ask your questions.
On the 13th at 3:46 p.m. This is on page 163 of your packet.
No, never got it. And it doesn't have the full email address, so I don't know where they sent it. I didn't get it.
So a quirk of Lotus Notes is when you are, say, printing something out or taking a screenshot, it doesn't show the entire email address. It shows this shortened version of it. But you'll see like where so that's to A010. That email went through. We got no bounce back notice. She received our response on the 13th.
Okay. How many pages is your... So apparently Ms. Trudeau hasn't received your response. How many pages are those two PDFs?
It's one page each. The response is one page. It's page 157 in your packet. That's the response. So what you see in those PDFs are the previous emails PDF'd and then attached on the 13th.
Okay. Ms. Trudeau, have you found page 157 in the packet?
Yeah.
Okay. Thank you so much, sir.
Yep.
I have two issues I'd like to bring up.
Okay. First, we're going to ask you questions, and maybe
Okay.
you'll get a chance to cite some things as well.
Okay.
So it sounded like you hadn't received this document before now. Is that what you were saying earlier, Ms. Trudeau?
When the agenda published is when I saw it.
Okay. So it seems to me that there was some sort of user error that resulted in it being properly delivered 3 days later, and then who knows why that delivery didn't actually arrive to you. It could have gotten stuck in a spam folder, or I don't know. But they have shown evidence that they sent it to the correct email address by the 13th. However, just let me finish.
Okay.
However, this is the response that we have in place. Other than the timeliness issue, do you have any objections to the response itself? Have you had a chance to review it adequately?
First off, if you look at the original IDR, it cites Margaret Baumgartner, who was in that office. I had a case in the State Court of Appeal, which lasted over a year with Margaret Baumgartner, and on every document was the correct email. All this person had to do was go there and ask her what was the correct email, firstly. Secondly, I sent a follow-up email on October 13th at 4:03, finding on my own, not a generic thing, but this Shane Gilbertson's email. And I said, I haven't received anything. You didn't include what you claim you sent on 1010 and didn't reference the other email. I have no idea what you're talking about. It's now 10:13, and I have not received anything. If you have not included a phone number. So he responds to my email on the correct email. And he just learned of it. It's a technical difficulty, and he's telling me he sent it to Trudeau too. Why would he do that? It was not listed on anything. So the claim of Lotus and this and that.
Okay, I see the timeliness violation. It doesn't sound like a willful violation to me, but that's going to be up to the task force to decide, not this committee. My question to you is, you have a response right there. It's blown up. You put it on the. Is that response comprehensive with your request?
No, it is not.
Okay, why?
As I said, Mark Tetro is not covered by attorney-client privilege of the city attorney's office. He is neither an employee, and he has nothing to do with San Francisco. So they just put a blanket attorney-client privilege on this entire thing.
Okay, do you have any other reasons that this is not sufficient?
Okay, I didn't get that information. All investigative notes and contact reports for the same time period. I didn't get anything. Request all documents taken from the projector and in Baumgartner's possession when I walked into room 416 after hearing at the Board of Permits and Appeals. Didn't get any response. This is what we have. This is what we don't have. This is what we're going to give you in a redacted form. Nothing. Bill of hours spent on the above case. That, I could say, somehow might fall into attorney-client privilege, but they didn't cite we're calling privilege just on this part. I got nothing. I got attorney-client privilege. That's it.
Great. Thank you.
Thank you.
Mr. Cody? So I think Ms. Trudeau just a few seconds ago outlined how a blanket attorney-client privilege appears to be insufficient. For one thing, she makes the case that who she's writing to in her estimates is not even a client of the city attorney because of their relation to the city. She also states that not all of the data that she requested would fall under a blanket attorney-client privilege by her estimates, and that she has a right to know the scope of what documents exist, even if the content of those documents is explicitly protected by attorney-client privilege. So what response do you have to those pieces?
So several points, Chair Wolf. One is that, as you see on page 157 of your packet, we did not issue a denial simply based on attorney-client privilege grounds. There are two other grounds that are cited there which are applicable here. So this is not just a blanket attorney-client privilege. There are issues governing work product privilege. Under two sections of the California Code, there is work product privilege under Government Code Section 6254K. And 6276.04, Evidence Code 950, and work product privilege under Civil Code 2018.030. So apologize for reading into the record all of the legal codes, but I want to make sure that we're very clear that we're not just asserting like simple attorney work-client privilege here. There's other aspects involved, not just whether this individual happened to be a client of the city attorney's office or not.
Sure. So it's your assertion that all documents in your office's possession fall under one or more of the privileges or exceptions listed within the government codes you just listed.
That's correct.
Great. That covers most of this. Now let's go back to the actual existence of the documents categorically and how many pages there are, because the content may be exempted, but it's not my understanding that the existence of those documents in a generic form would itself be exempted unless there's some read within that I haven't heard before.
So on that specific point, and as I imagine you'll agree, it's a pretty nuanced point. I don't know specifically what the documents that we have, if any, are, and whether or not disclosing the number of pages, et cetera, is something that would be compelled, or whether or not it's covered under one of these privileges. So I would need to confer with attorneys in our office before I could give you a response on that.
Sure, but where I'm coming from here is that now I don't know whether Ms. Trabeau plans to elevate this into a lawsuit or something of that nature, but we don't have discovery process in this venture. But in order for her to understand what she's trying to get, she needs to know what exists. Now, it's understandable that you can say all of this is privileged, but she, as best I understand it, would have a right to know that, like, there's a document related to XYZ that's a receipt, where it's a privileged receipt, but it is a receipt, so that she knows what documents exist to figure out which ones to pursue through any channels beyond the task force. Because right now her hands are tied. It doesn't quite say there may or may not be any documents, but it's a pretty much closed door that doesn't really even indicate whether there's something worth trying to seek or not. And I think that to whatever extent that if it was like, oh, there's 3 pages of documents and that's it, and this is what those documents are in generic terms, that she may understand that there isn't something to pursue. And so without the generic information about what these documents are, it sort of leaves everyone in the dark.
So again, I would have to consult with attorneys in our office to determine if providing generic information about potential records that exist, if that's something that's compelled under the code. I just don't know the answer to that.
Sure. This will more than likely, this will automatically be referred to the full task force no matter what our motion is. But I would ask that you look at those questions before this comes back, because it seems like a possible area that we would go down in the full task force.
Okay.
The complaint is 6725, which I think is aimed at both the timeliness of the response and the completeness. I'm asking. Yeah, please. Sorry.
In a normal world, somebody would have spoken to Margaret Baumgartner, since she was named in the original IDR, and asked her, well, what do you have? Who is this Mark Tetro? That kind of thing. We're now into February, when this thing was sent almost 6 months ago. Baumgartner isn't in here, Diana Rosenstein isn't in here, and by their own admission, or John Cote's admission, we never looked. We don't know. It's now 6 months later. So, because 3 orders have issued for this exact same thing, me not even getting a responsive email, and one more that I filed this morning for the exact same thing. I think they should be found in more violations, because they didn't obviously even look at the email. It's now 6 months later, and he's going to consult with Margaret Baumgartner or Deanna Rosenstein to see what they have. I didn't even get a clarification email. Who is Mark Tetro? What relationship does he have? Nothing. It was just generic nonsense.
Great, thank you.
Thank you.
Are we ready for rebuttals, or do you have any more questions?
I don't have any more.
All right, if we can go ahead and have closing remarks from who? It's the complainant that goes first?
I believe the respondent goes
Respondent.
first.
Thank you again. task force members. So, if I may just quickly follow up on a comment that Ms. Trabeau was making. As you'll see, she's completely misconstruing my remarks and trying to suggest that our office didn't look for these documents. That's not what I said at all, and I would refer you back to the comments that I did say, which was that I was not aware of a scope of any documents, if we have them. That has nothing to do with whether or not others in our office have looked at those and reviewed those, et cetera. So, to the more substantive point, this is simply a situation where the matter before you is about timeliness and completeness. On the timeliness factor, clearly there was something that caused an email to bounce back. The email was sent in a timely fashion. It bounced back. Could there have been an intentional error on the part of our office? That's certainly a possibility, but I think our actions in the immediate aftermath of that, sending a second responsive email within 10 minutes, demonstrated that we were doing what we could to actively comply with this records request from Ms. Trabeau. And I would just simply point out that the number of representations she's made here as far as contacting our office, not receiving emails, et cetera, we don't have anything on the record to substantiate those claims. In addition, this email that she has just presented today didn't provide to this body, or it certainly wasn't included in the packet from the 13th. I haven't seen that email yet. She's just been waving it around. I don't have a copy of it, so I'd request to have that provided before any additional follow-up hearings. So, thank you.
Thank you, Ms. Trabeau.
Firstly, I refer to various complaints filed against the city attorney's office, and I ask that you fine for 6721E for failure to appear at a hearing. Had Deanna Rosenstein come in here today and had you asked her directly the content of the IDR, we would know directly what the search methods were, if she had any information available, that kind of thing. Instead, it was sent to her, but it was sent to another guy who made the mistake a number of times, and now this guy is coming in. Because I called the city attorney's office and asked for the guy, is the burden on me to produce their phone logs? I don't think so. We are not held to the standard of writing legal briefs here. I sent an IDR, I asked for specific information, and by listening to the audio of what was said here today, John Cote said he didn't know. He would have to ask the attorneys, meaning it's 6 months later and nobody bothered to ask Deanna Rosenstein, who this IDR was sent to, what she knows about this. So, it happens over and over again. Ray Hart's got a few violations. The one before me today was for basically the same thing. Failure to appear, sending somebody else who's going to make claims of Lotus and this and that. I've heard that 3 times already. This is the exact same mistake they've made 3 times in the past, and one that was filed today. And they have a long history of doing this. They didn't look at the IDR. Now 6 months later, he's going to ask the attorneys. That sounds a little suspect to me. And as far as finding this, yeah, I had to search through a lot of emails in order to come here thoroughly prepared. I don't need to do that. I send an IDR, they might ask for an extension, a clarification, and then come the documents. That's the way it goes. It's written in stone. It's not we sent it here, but we sent it there, but you need to provide phone logs or proof that you called our office. I don't think so. The Sunshine Ordinance is very clear and very specific. These are the documents we have. This is, as you said at the last hearing, an index of records. of what's available. These are the categories. These are the records that are subject to disclosure. These we have to look at and possibly redact, and these may come on a rolling basis. That's the Sunshine Ordinance. It's very clear. And especially in 2014, when Matt Dorsey was in here and was ordered to produce a procedure manual to the full task force to be referred back to this committee. He didn't even appear.
Great, thank you.
You're welcome.
All right. What are you thinking?
I'm nervous about making any recommendation regarding the contents of the response, because I think the task force will have a few different thoughts about where that should go. But it does seem like, for whatever reason, it seems to me unintentional, but that's my personal perspective. It seems like the timeliness violation, which is sort of our standard operating procedure when, for whatever reason, if somebody doesn't get back the request in time.
Yeah, I mean, I'm pretty much coming down on the timeliness, and it seems like it is to be adjudicated by our task force about whether or not an index of what privileged records exist is within the purview of the requirements by the Sunshine Task Force, or Sunshine Ordinance. However, I don't see a likely violation there so much as, compliance of providing additional records.
Sounds like you might have a motion in mind.
I mean, the motion would be to find jurisdiction and to recommend a 6721.
Yeah.
A 6721 violation for timeliness, and to look into potential issues around privileged information. I don't know how to. Victor, any guidance for how to include the targeting of looking at how to deal with the completeness of the
request
response?
the task force review whether or not it is required for the respondent to provide an index of records that they may have, and the code sections that allow for it to be withheld.
Right, an index of withheld records.
Yes.
Great. That sounds great. That's the motion. You want to second it?
Yep, I would like to second.
Any public? Well, there's still the public here. Ma'am, did you want to make any public comment on this motion? Seeing none, go ahead and call the roll.
On the motion, Member Eldon.
Aye.
Eldon, aye. Fisher, absent. Chair Wolf.
Aye.
Wolf, aye. The motion passes.
Great. Go ahead and call the next item, please.
Next on the agenda, item number 8. Announcements, comments, questions, and future agenda items and pending calendar by members of the Education, Outreach, and Training Committee.
What's your question, Mr. Bell?
Okay,
You don't need, I guess, go ahead and...
Firstly, to include that in the filing, and secondly, if you could give some indication when it would go to the full task force.
That'll be up to our board chair, so it's not within the purview of this room. And Victor, can you go ahead and take that item that Mr. Bell wants included
I will
in the...
momentarily.
Great. Awesome. Everything's taken care of.
Thank you
Thanks.
so much.
I have no announcements.
I have no announcements.
Next on the agenda is adjournment.
All right. Adjourn.